The red light begins to flash, you have to stop.
Yes, ma'am.
Okay?
Yes, ma'am. My name is Janice Stevenson. I am the plaintiff in the case of Cafasso Properties versus Janice Stevenson. The single justice denied my application. However, I feel the single justice failed to ensure that judicial and court practices and the state reliance on alternative and appellate remedies do not constitute a, number one, violation of the regulatory taking or rejects the U.S. Constitution. Number two, violation of the exception clause of the U.S. Constitution. The summary process courts focus on speed. Number three, violation of due process and equal protection clauses of the Constitution. My case as a plaintiff in the summary process is complex and time-consuming. The Supreme Judicial Court mandates that as a pro se, I'm held to the same standards as parties who are represented by attorneys. However, during those proceedings, the landlord set the standard. He kept telling the judge it's just a summary process case. No third parties and no extraordinary discovery. Number four, the single justice failed to ensure that there was not a violation of the Judicial Act. He should have ensured that the judge or the court in that proceeding had subject matter jurisdiction of the parties, and that in number five, he should have ensured that I was not denied access to the appellate process. 99.9% of my motions were denied. And with that limited evidence, I had to go to trial. And the jury made a judgment that was based on insufficient evidence. There were lost trial tapes, and I was denied transcripts of hearings in order to appeal. Number six, the single justice should have ensured that I was not denied a fair trial. I had difficulty obtaining third parties in my proceeding and obtaining public records through the discovery process. Part of the summary process involves counterclaims and defenses that I was not able to obtain through discovery. My discovery was timely filed with my answer, and within the summary process case, it was the landlord who set the standard. It was the landlord who would not provide me with documents that I needed for my trial. And in addition, there were public records that I had a right to on written request that I had to turn to the court to obtain, and I still could not obtain that evidence for my summary process case. So I had a trial, and I was set for trial, and I came to the single justice because I needed that evidence in order to ensure that the jury had the facts before them to make an accurate judgment. So I feel that the alternative remedies or appellate process that the single justice relies on, or that you ask parties who apply to the single justice to make sure that there are none, I feel like that process deters from obtaining justice the first time by people who are in the lower courts. When I came to the single justice, all I wanted was just to get that evidence so I can go to trial. And even though it is a civil matter, it wasn't a criminal matter. That lack of evidence affected everything from not only the judgment in my trial, but also the appeal process. Because you have to come to the appellate process, a court, and show them evidence or documents that say despite what despite the judgment, or this is a summary process, I do have good legal reasons, a good legal questions and options that were not addressed in the trial. But I couldn't even get enough evidence to even address that to the appellate court. So evidence through discovery in my summary process case affected even my coming here because I could not even obtain a transcript. I was given the tape, but I couldn't even obtain a transcript. And I think the lack of access to the appellate process should not have happened in this case. And I really do think, even though I elected not to have an attorney, if I followed the same civil procedures, I filed timely, I should not have been treated differently. Because I know a lot of pro se's come and they haven't crossed their T's or dotted their I's, and they want the court to make an exception, and you says, no, you're held to the same standard. But within that process, there seems to be where attorneys change the standard within the court. And I know this court has superintendents over inferior courts. And when a pro se comes to you and says, look, I'm not being treated the way civil procedures say it would be, or if I were an attorney. So you come to the single justice, and a single justice, according to your law, the state law says, well, there is an alternative, or there's an appellate process. But in the meantime, you lose property interest, or you don't get evidence you can't recover in the appellate process. So the landlord gets his property, and I lose my interest, I lose my home, because the single justice or the state relies on alternative remedies or the appellate process.
Ms. Stevenson, what was the amount of the appeal bond that had been ordered in your case?
They set it at $20,000, I believe.
What did that amount represent?
I think the attorney said it represented what would, if it went to appeal, what would be owed at that time. In addition to, because there was a judgment. But he kind of projected how much it would be owed.
I'm looking for your discovery request, which I know is the basis of your appeal here, and I can't put my finger on it at the moment. What specific items were you requesting in discovery that you were not permitted to get?
Well, part of the answer was it was a printed out form, and I checked out quite a bit. I checked out inspection reports. I checked out maintenance repairs. I checked out I think one of the bank records because I wanted copies of my deposit.
These were forms in the court itself?
These were forms within the court itself, or from Mass Legal Help.
Okay.
And it was attached to the answer. And I know the mandate in the courts is that the summary process should be speedy. Mm-hmm. And I think that mandate somewhat limited what I could get as a plaintiff.
What was the amount of the judgment that the court ordered against you?
About $14,000 and some odd dollars.
Back rent?
That's what they said. It was for, at that point they said it was for back rent. But when I was served the notice of the notice to quit, I was not aware of what the amount of money was that I owed. But I also told them it wasn't a non-payment case. It was a sanitary issue because there were severe code violations that the landlord had violated.
But were you able to get inspection reports of your apartment?
I was not able to get a complete inspection report. It was in Cambridge, And the inspector came in, and the first thing he said was, give me the landlord's number. I'm going to call him, and he will remedy it. I'll get him your letter, and he will remedy it. And I says, well, the basis for me calling you was because he was aware of items that needed repair in my apartment, and I wanted a written report. The first housing inspector, Mr. Henry, Jim Henry, refused to write it. I had to call the state board, who called the city board, and they sent a second person over who only did what he was an expert in, and that was ask him to repair the heat, because I was without heat. He refused to do the other inspection because he said it wasn't his job. At that point, that's an administrative process, and I went through that with the city, and I tried to obtain those associated records, and I couldn't get it through discovery. I couldn't get it through a motion to compel, and it ended up with a landlord said, well, she could get it with a subpoena, but public records, I'm sorry.
That's okay.
You were answering a question, but thank you, Ms. Stevenson. I wish that all the people who saw that red light flashing stopped as quickly as you did. Thank you very much. Maybe council will take a hint from you. Ms. Stevenson, we will consider your request, and at some time in the future, not today, we will issue an order and send that to you. Thank you, and I'm sure if you have any questions, Ms. Mellon will be able to answer them. Thank you, Ms. Stevenson.